Welcome to Notes to My Legal Self. Together, we explore topics of interest to in-house lawyers. Let's begin. Here's your host, Olga Mack.
Well, hello everyone. Welcome to Notes to My Legal Self. I'm really excited to have this episode. We're going to be focusing on contracts and AI. And I am really excited for you to meet my new friend. He's not new to many of you. Actually, he's friend to many of you. I recently discovered him, even though we were basically neighbors and lived parallel lives. I had an opportunity to be with him on another webinar and love his expertise. And I thought I need to bring them to you so that we can have important conversation about AI and contracts. And so without further ado, John, welcome to Notes to My Legal Self. Please introduce yourself.
Great. Thank you, Olga, for having me. Excited to be here. I am John Pavolotsky. I am based in the San Francisco Bay Area, offices in San Francisco. I'm a technology transactions, privacy, and cyber, and now, AI attorney. A newer development, I think, for some attorneys, but it's a space that I've been in terms of technologies for the past probably 10 or so years, and excited to join you again this morning.
You had this fascinating career of being at a law firm and house back to a law firm. I think it's really fascinating and really sort of shows what's possible today and how much of not so rigid past we as lawyers can have. So folks can understand your experiences and expertise. Maybe share a little bit about what was the scenic route you took to be where you are today?
Scenic route is a good way to put it. So I graduated law school 25 years ago to this month from UC Davis. And my first role was in-house for a travel technology startup. And there, at that point, the technology focused on an on-premise implementation of the company's software, but there was a new business model for the application service provider field of use and for service bureaus as well. An application service provider in the mid-2000s became on demand, became SaaS, became cloud services. And fast forward, we now have AI and various implementations of that. From there, I continued to Sugar CRM, mid-2000s. From there, Greenberg Traurig and their IP and technology group in San Francisco. After 3 years there, a long stint in-house at Intel, first part of their technology and manufacturing group, global supply management, technology development, and then supporting the privacy and security legal function, and then finishing off my time there in the data center and AI groups. This was, late 2010s, early, 2020s. From there for another in-house role at Roku, and for almost the last 3 years at Stoel Rives in San Francisco, where I co-head the privacy, cyber, and AI group.
It's fair to say you've done a few things.
Definitely a few things, and going back, certainly if you asked me 25 years ago, would this be the route taken? I mean, who would have imagined kind of where technology would be? And I mean, likewise, who would imagine kind of where careers might go? But the common thread is technology and kind of being at the cutting edge, and listening and hearing things where, when they're presented to you, the initial reaction is like, there's no way that's going to happen. And then fast forward, 2, 5, 10 years, and it's happening. And that's been kind of the theme throughout.
So I'm going to start with a very easy question. How do you draft AI contracts when regulations are changing so quickly?
The approach I take is, you focus on kind of the areas that, at least I do, where I know there's going to be change. And that's going to be in the privacy space, in the cyberspace, as well as it relates to AI. And also in terms of what I call kind of higher risk use cases, or maybe perhaps restricted use cases. And there, I know that the laws are going to change. And it's hard to tell exactly where things are going to go, in as much as the states have always been labs effectively for law development to come in the technology space. We're certainly seeing that in AI. I think California has 45 to 50 laws that are nominally AI related right now. And there's, at least in the House bill that was passed, the big spending bill, and in the Senate bill that's currently being considered, a 10-year moratorium on AI laws being enforced by state governments and their political subdivisions. So it's hard to tell kind of where things will go, but I know that there are areas where there's going to be change. And so you kind of drafted to reflect kind of the lay of the land right now, where things might go maybe the next 6-12 months, and include language that gives you the ability to update the agreement as laws change, given the space.
So I like this tip, watching what's happening at states level, especially sort of active states. States are known for their activity, like California, New York, Texas, states like that. That's a really great tip, and kind of identifying what's likely going to come up in the next 3 to 5 to 10 years. I think the other thing you mentioned is the higher risk use cases. I'm wondering, kind of, what do you think those are, and maybe more interestingly, how do you systematically identify those?
Conveniently, I guess in part the EU AI Act, has those enumerated. The Colorado AI Act, which goes into effect and can be enforced, as of February of next year, unless this 10-year moratorium is agreed to, lists those high risk use cases, and they are kind of what folks would expect them to be. So where AI is used in areas where there is the potential for a significant kind of legal impact, that would be education, housing, financial services, government services, anything that has to do with relates to kind of the livelihood of individuals. Those are higher risk use cases, and that would require specific risk assessments, documentation that is made available, if you're a developer, to a deployer, and ultimately potentially to a consumer as well, and other protections as well. So we have a blueprint of those, and there's kind of ways to address that. And certainly if you are a developer or even a deployer of an AI solution, these are things that are probably top of mind. And if not, as I said, they're fairly easy to find.
I think what you're alluding to is sort of also changing risk calculus and calculations, and sort of changing in potential liabilities and licensing terms and stuff like that, and compliance. What are you seeing shift when it comes to AI? What should we expect with respect to liability, to compliance, licensing? What changes, practically speaking, we're gonna see in the short term, medium term, long term?
Short term, where companies are at is, companies are experimenting with generative AI tools, and I'm speaking on specifically in terms of your generative AI that seems to has kind of the greatest attention, and so that's still happening. And so the question is going to be, so if I'm talking to a client that is potentially using these tools, how are these tools going to be used, by whom, what are the expected inputs, what are the expected outputs? Do you care about owning, or kind of what your rights are to the expected outputs? Do you care if the system uses your inputs or the outputs to train the model? And so it ends up being, probably as it should be, use case specific, which is kind of where the conversation goes. So trying to kind of address this at a 30,000 foot level and or kind of boiling the ocean for all possible risks. I mean, it's not worth kind of the calories, frankly. I think the better approach is kind of understand kind of what's going to be done and then kind of chart a course accordingly.
So I remember, 2007, 8, 9. That's when I was transitioning in the house. Everybody was looking for a SaaS lawyer. It was quite disruptive. Everyone was looking for one. There was none really, and so every conversation I had was, "Are you a SaaS lawyer?" And at some point started asking, "What would you like the answer to be?" So I'm curious, from your point of view, the level of disruption that we're gonna see in sort of contracting and risk calculations, and maybe even job security, because I think that's what a lot of folks worry about. How will that compare? Is that going to be like similar? Is it going to be less because we've had a learning curve when it comes to SaaS? So we're just going to build on top of it so we kind of know how to handle it? Or do you think it's going to be massively different and it may have a bigger impact because it is a fundamentally different technology that will necessitate a different business model and therefore completely recalibrate the entire system?
One way to look at it is like fundamentally that, I mean, obviously it's AI runs on hardware, but it's software. And they're obviously they're specialized chips to go ahead and kind of process the data kind of runs through operates these models, but it's software. I mean, so SaaS is a business model. On-prem or deployment on premise is a business model. AI is, I mean, it's software, but it's not really a business model. And I think the challenge is going to be, one, understanding how these tools will work. I guess maybe taking a step back, how these tools should work, and then understanding, hopefully, how these tools will work. And then beyond that, kind of what are the risks if the tools work as they should work? And what are the risks if the tools do not work as they should work? And so, I mean, I'll give you a simple example, which, I mean, it's not here yet. I think, probably give it a couple of years, it'll be here, which is using an AI tool, to book a vacation. And there's an article on The Economist on it, relatively recently, which is quite interesting. And the consensus is that, I mean, kind of the current cohort kind of isn't there yet. But you can imagine that, I tell an AI tool, okay, I want to spend a week hiking through the Bavarian Alps. I want to start in this village. I want you to plan an itinerary. I want you to go ahead and book 3 hutas, or these are basically kind of army style barracks you would hike up to. I want you to go find me a local guide. Here's my credit card. Go for it. Here are my dates. Book my air as well. We're not there yet, but I mean, once we get there, which is probably going to be sooner than later, it's going to be a very interesting, and I think for some, probably including myself, enticing product. And so if it works as it should, then I tell my what my requirements are, and the results are I've got a planned trip, everything's fully booked, it's insured, and I'm going to the Tyrolean Alps or the Bavarian Alps, in September. Great. The possibility, of course, is that, what if something else gets booked? What if my credit card information is compromised? What if the AI tool is fooled by another AI tool? What if the communication is not secure? If you have AI tools talking to other AI tools, which, security authentication, I mean, as I understand it, isn't quite there yet because the protocols are being worked out. And so comprehending that, which then it kind of goes to the difference, the main difference, to my mind, is you have to, I think in these cases especially, really understand kind of what the product is and what the intended outcome is, and then kind of work backwards to identify risks and to mitigate them.
I love that example. About a year ago, I gave a TEDx talk about I built a tool on top of OpenAI using Airtable to suggest what I should do in Iceland. And it systematically gave me a list of recommendations. Some of them were quite good. Some of them recommended that I stay in the ice hotel. I actually don't like being cold very much. And so it was really interesting to kind of see various things, this system. It wasn't quite agentic at the time. This was not the word. I used the kind of the no code tools to systematically create tables and parse them to give recommendations that kind of more or less jive with my lifestyle. And even there, knowing a lot about me, there's a number of interesting things that I would never choose for myself. So I can absolutely imagine mistakes, innocent and not so innocent, being made and impact it will have on the experience. But I want to come back to what you said about, in the end, AI is software. I think if you sort of take AI and augment essentially a SaaS experience, I think maybe at that point the business model doesn't change very much. It just sort of automates and kind of rounds corners. But if you sort of imagine the world that you were describing, a much more agentic, where decisions are made without you, where a human delegates a lot of things, and you take it a mini step forward, bots talking to bots, doing all kinds of things. I'm curious, do you really think that at that point that we're still operating from fundamentally the same SaaS model, business model, and therefore I guess similar risk just with slightly different facts? Or I think at that point we may be actually looking at a different business model.
It's once we get to that, and we're not there yet, then to my mind, it's a paradigm shift. And so you can imagine that. I mean, if I'm using, let's say, a SaaS, deployment of a CRM solution, then okay, I'm putting I guess it has some agentic, elements in it perhaps right now in terms of workflows, and a chat bot, might be integrated into it and so forth. So I mean, we're moving the needle a bit, but it's not me and bots, talking to each other. That would be, to my mind, quite, if not vastly different. And then you have kind of these kind of raft of issues that come up, and how to mitigate them. And I think the other thing which I think is very interesting here is that we know, I mean, generally speaking, kind of how the human mind approaches a problem. I don't think I guess if you would agree that there's certainty, or even close to certain terms, how if you have a super intelligent system, how it would approach and solve a problem, and what steps it would take, and whether or not it would kind of come to the same conclusion that if you had an individual who's highly trained confronting the same problem. And so I mean, that's not an original thought. I mean, if you read about books about AI, I mean, it's in there, but that is a bit of a wild card. Which then kind of brings me to the next point, is that, okay, if there's a 10-year moratorium on laws in terms of state enforcement of laws, I mean, that have to do with AI, and kind of defining that is going to be quite an exercise, given that there's really very little at this current point in terms of kind of where the federal government is in terms of legislating AI and putting guardrails in place. Where are we going to end up? But that's a bridge to be crossed, perhaps on a different day.
All right, let's talk about pragmatic, practical, tactical things. Because for many folks, they are doing their best today to deal with that uncertain reality, unpredictable reality, I don't know, n number of days from now. So them or somebody who inherits their seat, I'm not going to be saying something along the line, what the heck was Olga thinking? So if you want to be thought of kindly by, folks who follow you, interpreting the steps and risks mitigated, what are sort of best practices you can take today so that you can position your clients for success and yourself for, I guess, no pressure, good legacy?
So I think the first thing that you could do pragmatically is integrate, to the extent you're comfortable with, AI into your contract preparation, review, and kind of updating process. And so it's effectively, pick a few tools and, get comfortable with them and understand what they can do, what they can't do, and they can do kind of well, perhaps not so well. and look at the inputs, kind of work on kind of getting, using perhaps more precise prompts, look at the outputs, test it against, laws that where what the answer is, and see kind of how accurate the output is. And so that's one piece. The other piece is, again, I think it depends on what side of the table you're on. If you are representing an AI developer, then and you're licensing your technology or making it available to a deployer, and that the agreement is not going to be negotiable really, or kind of given what the spends are, then there are forms out there which are quite good, which are a starting point. And then it's kind of taking that and validating against your engineering team and the documentation to the extent that it exists, hopefully, with respect to your solution, to make sure that you've got a good fit as of now. And then 6 months from now, rinse and repeat. If you're on the developer side, if you're on the deployer or customer side, then it's, again, kind of understanding kind of what the use case is. And again, kind of have a conversation with your, whether your sales folks or your product folks, whether you're integrating the solution, to make sure that you're getting what you think you're getting for the solution. And if you have sensitivities, for example, you don't want the tool developer to train their model on your data, then that is called out in the agreement. And if you are, at least my experience is, that if you don't want it used, then you have that conversation, and there will be a mechanism proposed usually in terms of how to do that, as long as you're paying some amount, and you go forward. But again, it varies kind of where you're sitting. And I guess the last thing to keep in mind is that you could, at a given point, for a solution, you could be a developer, a deployer, you might even be a consumer of a solution as well. And so understand kind of what hat you're wearing. That's going to drive your review and or preparation of the contract.
I want to double click on the first part because I find it very intriguing. In life, I'm very fascinated with what I call judo moves. You use the energy of an opponent against them. I think it's a very powerful move. And so I think that's kind of when you suggested use AI to help you draft better today and do it safely. I'd like to kind of not gloss over it, but kind of how and I'm not going to put you on the spot, what do you use, but how have you seen what specific conversations or custom GPTs or whatever you've done, what have you seen kind of useful for that purpose to use the tool today to buttress your position tomorrow?
There's a couple of ways to look at it. You can use a tool, and I've experimented with the tools to draft an agreement from scratch. And I will provide prompts, and I'll get an agreement, and then it's sort of there, and then I have to provide additional kind of detail or instructions to kind of get it closer to where I want it to be. That's worked okay, given that I can also always find a form, either something I've used before, or find a form kind of as a starting point. Where it's probably more useful right now is that if I need a specific provision or clause, then I can go ahead and use an AI tool to prepare that clause or provision. And then I can take that, I can massage it a little bit, 5-10 minutes, make sure it's got the piece that it needs, make sure that the context is correct. And then that's a work product effectively. The other thing, there's many things you can do. You could take a complaint, which is of course a public document, you could feed it into a tool, and it can identify potential defenses. So it's a tool that, if you get comfortable with it or comfortable enough with it, it's able to obviously kind of generate new, content for you, but it's also able to, I think, pressure test what you have created, bearing in mind that, there does have to be, that human check, at the end, to make sure that, all the T's are kind of crossed and all the I's are dotted.
Yeah, you definitely can't drive it asleep behind the wheel, right? but it also can give you this opportunity to play various scenarios and think through risks and buttress your outlier or more likely positions. I love that. I have time for a few more questions. I want to sort of zero in on the role of lawyers in shaping this landscape, not just sort of consumers and receivers, what's happening at the state, at some point federal, definitely international level. But as I say, in-house practitioner or a law firm practitioner, what are the things I can do to, at a minimum, be part of the conversation and share the reality so they are coloring where things are going, at least in my industry, and maybe even kind of more broadly? What are the practical steps would you recommend that practitioners take, depending how much interest and time they may have after a busy day?
Well, I think you've hit the nail on the head. Interest and time after a busy day. And so with that, I think, ideally, you're able to, or folks are able to kind of integrate this into their day. And it's not, it's, different than saying, okay, I'm going to go, take 10,000 steps today. I've got a goal. I've got to hit it every single day. I've got to spend 30 minutes a day experimenting with AI tools. I'm not that prescriptive or dogmatic, but certainly in the back of my mind, if there's an opportunity to experiment, I will. Just going to see what these tools can do, and perhaps you can't do at this point. In-house counsel, and kind of having spent a large part of my career in-house, are uniquely positioned to have those conversations with technologists, especially if you're in a technology company, to understand how the technology kind of works, kind of what is in the roadmap, what are the limitations and so forth, and see how that kind of develops over time. And so, for example, like 10 years ago, the conversation might be, okay, I've got vision processing technology, and okay, I can differentiate between a person, a tree, and a cat. And obviously, that has evolved substantially since then. But understanding kind of what the technology can do and kind of what the roadmap is for it, and then kind of taking that and translating, kind of thinking through the issues that exist, and kind of starting with the agreement and kind of fanning out to whether it's an acceptable use policy or other kind of ancillary documents. That's something that folks in-house, I think, are uniquely positioned to do. For outside counsel, yes, I think there's the benefit of seeing technologies from different clients, and perhaps kind of being on different sides of deals. That you could do that within an in-house legal department as well. So it's complementary, but if there's a chance to speak with your in-house clients or colleagues or acquaintances and kind of talk about kind of what's happening, or to talk with the technologists, that's certainly quite helpful.
It's fair to say that technology is essentially trending toward sort of more autonomy and speed. That's a general trend for last many decades and centuries. I'm curious, in your view, do you think legal frameworks generally, specifically for contracts, are they ready to sort of support that increased autonomy and that speed? If I want to be really futuristic, I would say approaching singularity, but maybe I'll stay away from it. Let's just make it simple.
the process, even 2025, it's not a fast process. It's like, okay, we've got a new product or line of business or service, we need a contract for it, draft a contract for that. Okay, let's talk about it, let's update it, let's revise it, let's send it over, it gets reviewed, it gets redlined, there's a conversation, there's multiple conversations. It's 2025, but that's a 2000 process. Am I advocating having bots negotiating contracts and then humans not look at it? Like, no, I mean, that's not going to happen anytime soon. I don't think we want that to happen. At the end of the day, ultimately, I mean, we want speed, but we also need precision and we need accountability. And so there's going to be kind of, that tension. But that said, are we going to be in a place, I mean, not this year, but 5-10 years from now, where the contracting process is faster and more automated? I think so. But for that to happen, I mean, you would have to, and this has been the issue, at least for the past 25 years, you would have to agree on certain language and say, okay, for both sides, this is good enough, let's move on. And humans have a hard time doing that. And AI, which is currently being programmed by humans, though I guess AI can morph on its own over time, is going to be reflect that same sensibility.
I hear in nature, speed and precision are inversely related.
That's the issue. I'll give you just one other kind of quick example, sort of related, where I was kind of going through my garage a couple of days ago and I found a stack of CDs, and I've got a car that still has a CD player, and I put it in and I was kind of listening to it and like, track 1, track 2, track 3, kind of going through it. I'm like, interesting. It's a kind of slow, sort of methodical process, and certainly like we've made, you can right now, as I say, I mean, you could draft a contract using an AI tool, and you of course kind of want to augment it with other languages as well, and conversations. But it is going to advance, and that I think it's going to happen probably quicker than folks think. And the way to, certainly, I think if you're an attorney, to kind of help future guard against that is you have to get comfortable with the current generation of tools, and you have to kind of start thinking about what these tools might look like in the near or not so near future, and kind of figure out kind of what your value add is. And the value add is, to my mind, really it's context and being able to kind of dig into areas that right now these tools can't do, and develop for the developing of that skill set.
It's funny using CDs as if it's like an old school technology. My daughter asked for her graduation gift to get a thing that plays vinyl records. And she bought a bunch of them for Taylor Swift, and she thinks they're amazingly cool. Now, I did not grow up with that technology. I grew up with the next generation technology of cassettes and CDs. So,
Well, it's the thing. Vinyl is back, and it's retro, and it's cool. And I mean, there's some vinyl at my house, and I enjoy listening to it. CDs don't have that cachet. It's like, what is this relic from 25 years ago or 20 years ago or whatever? And why'd I have to listen to the entire CD? I mean, I guess I could kind of jump from track to track, but it's it's older and doesn't have cachet, and but who knows? Maybe in 25 years it will.
I don't know. My mind was blown. I never thought I would be a proud owner of this massive pink thing that plays vinyl records. That's all there is to it. Maybe last question before we wrap things up. What is the one thing or a couple of things you can do to prepare your team, to prepare your clients, to deal with, big distractions and small that come with this new AI regulations and changing in risk calculation and frankly, possibly business models?
Covered, I think, probably quite a few of the things. I mean, certainly, as mentioned, experimentation is a huge one. The other thing, and kind of one of my kind of guiding principles, is that there are a ton of bills out there. There's some laws as well. They're developing regulations. There's a fair amount of commentary. There's a ton to track, and trying to do that certainly kind of agnostic of your business is probably not the best use of time. And so really then the exercise is, okay, here's the area, here's our sandbox. And given where we operate, what sort of risks, do these kind of next generation or current generation of, bills and laws present, and also opportunities as well? And, how do we effectively contract to reflect those risks, to allocate risks appropriately, to hopefully create, to the extent possible, a kind of win-win situation with the other side. So a focused approach, and certainly having conversations with folks, that have experience in it, I think is useful.
We've come to the end. We've covered a lot of ground. What is one takeaway you want folks to take from this conversation?
One takeaway is, I guess from one conversation is, to have many more. And I will assure you that your thinking on the topic, and the more time you spend with it, will evolve over time. And these conversations, can happen anywhere. It can happen obviously with your colleagues. If you have with other, with family members, with folks that are actively building these tools or using these tools, look at videos, demonstrations of them, experiment with them. It really is a point where you have to roll up your sleeves. And I know that attorneys are doing that already, and that will have to continue, if not accelerate.
Absolutely. John, thank you so much for this conversation, for learning together, for encouraging folks to get in, dip their toes, and really experience this technology and understand what's happening legislatively, understand what's happening in their business, and perhaps even using this technology in their lives and in their practices. Thank you so much, everyone, for joining. I'll see you next time. Bye-bye.
Thank you.
Thank you for stopping by. We hope you enjoyed this episode of Notes to My Legal Self. Know someone who'd make a great guest? Let us know. Self-nominations are encouraged. They are an act of courage. Remember, the future of law is bright. Enjoy your in-house practice. It's an adventure of a lifetime. See you soon.